Okay, so good evening to Sir Michael Clinic. So today we want to present about assignment 2 and we are from MSUC Seremban. So this is our team. First is me, Aisyah binti Zan Abidin. Second is Nurul Izzati binti Muhammad Syahran. Third is Lauhami and the last one is Wabina, anak perempuan Mutu Kemarin. Okay, so for introduction, law is a set of rules that are created and enforceable by social or governmental institutions to regulate behavior. With its precise definition, a matter of long-standing debate. This has been variously described as a science, as the art of justice. State enforced law can be made by a group, legislature, or by a single regulator. Resulting instituted by the executive through decrees and regulation or established by judge through precedent, usually in common law jurisdiction. Okay, so legal system are vary between jurisdiction with their different analysis in corporation law. In civil law, jurisdiction, legislature or other central body codifies and consolidate the law. And the last one is the scope of law can be decided into two domains. Public law concern government and society, including constitutional law, administrative law, and criminal law. Okay, so next.
Okay, hi sir, my name is Nahomi. I will be talking about question 1. Employment Act 1955 provide the basic right for employee in the private sector and identify the similarity and the difference between the provision in the management in the Employment Act 1955 in the Malaysia with one other country. So for the similarity and possibly the first point. Okay, so the first point is about employees and employer in Malaysia, like those in Hong Kong, are subject to an equivalent of mandatory provident fund, (MPF), naming the employees provident fund (MPF), with employers mandated to contribute at least 12 to 30% of employees' wages to the EPF saving. And this varies from Hong Kong, where the employer must contribute at least 5% of their employees' income to their separate MPF saving. Okay, so I brought it to the second point. The second point is the minimum wage laws exist in both Malaysia and Hong Kong. And Malaysia's Human Resource Minister said that on December 27, 2022, that a further delay is allowed for the firms with fewer than 5 employees. And for in the employees with the fewer than 5 employees must give them the 100 ringgit monthly minimum wage. And for Hong Kong, the minimum wage ordinance took effect in 2011, and it also established a statutory minimum salary for all workers. And this rule was meant to safeguard low-wage workers while also allowing Hong Kong to stay competitive and on a global scale. And the current minimum wage is Hong Kong dollar 37.50 cents, and it also applies to all Hong Kong workers, excluding domestic assistants. And I proceed to the third point. The third point is the same law applies for Malaysia and Hong Kong, where the number of working hours should not exceed 8 hours. In Malaysia, an employee normal working period and nighttime working time should not exceed more than 8 hours per day and 5 hours per week. The speed over duration of labor should not exceed 10 hours per day, exclusive of overtime, which include rest intervals. Okay, so for Hong Kong, the regulations are classified into 3 types. The first one is the default standard system, the comprehensive method of calculating labor hours on a weekly, monthly, quarterly, or annual basis, and the flexible system. And the work days are limited to 8 hours per day, which is the same as Malaysia, and 14 hours per week under the conventional system. However, the implementation of the comprehensive system or the flexible system is restricted to the specific position and requires prior authorization from the labor authority. And last but not least is the last point. So the employees in both Malaysia and Hong Kong are entitled to annual leave, sick leave, and maternity leave. Employees in Malaysia and Hong Kong must use up their remaining annual leave before proceeding to the following year, as the annual leave will be considered expired if they are not used. And the maternity leave is also available in both countries, which allow the female employee to take paid time off from their job. Both countries also provide sick leave, but they must give the medical leave, like medical certificate to get paid back. So that's it from me. Thank you, sir.
Okay, so I proceed to the differentiations. For the first question is first one is for annual leave. So in Hong Kong, employer under a continuous contract are entitled to a minimum of between 7 days and 14 days of annual leave depending of the length of continuous employment for each period of 12 months employment. So in contrast, employees in Malaysia are entitled to paid manual leave, which is like Hong Kong, is also dependent of the length of continuous employment, but range from a minimum of between 8 days and 16 days. Also in Malaysia, probation is not defined in the EA 1955. Thus, probation enjoys the same right as a permanent or confirmed employee, such as annual leave, holidays, minimum wage as prescribed under the relevant employment law or the contract of service. Next point is the minimum wage, which is ordinance provide that the statutory minimum wage in Hong Kong shall be per hour, whereas the minimum wage state in Malaysia, minimum wages order 2022 effective 1 January 2023 will be RM 1,500 per month and 7,021 per hour. Third point is a breakthrough moment for employment law in Malaysia happened with the new section, which is the following the implementation of the EA amendment, where newbie fathers are entitled to 7 days of consecutive paid paternity leave, subject to being married to the mother in question, being employed by the same employer for at least 12 months, and having had noticed the employer at least 30 days. And the last but not least is working hours. For Malaysia, an employee's normal working time and working time at night shall not exceed more than 8 hours per day and more than 45 hours per week. And for Hong Kong is indicated decrease by 8.3% between 2010 and 2021. Working hours per week in Hong Kong was highest in the year 2010 at 48 hours per week, and from 2011 to 2050 it was 45 hours and was lowest from the years 27 to 2021 at 44 hours per week. Next, I will pass for the next presenter.
Okay, hi, good morning. So I'll explain about, based on your review, please recommend new provision for incorporation in the Malaysian Employment Act. You may choose to compare the Malaysian Employment Act with similar act in other countries such as China and Indonesia, etc. So the Employment Amendment Act 2022, which purposes the amendment to the Employment Act 1955, was presented in Malaysian Parliament. As we can see, pregnancy and maternity leave increases 60 to 98 days in order to follow up with international labor standard. Moreover, if a female employee is pregnant or experiencing a pregnancy-related illness, her employer is not permitted to terminate her employment or give her notice of termination unless there has been a knowing violation of a term of the service agreement, misconduct, or the company's discontinuation of the operation. In China, maternity and pregnancy leave are granted following their own circumstances, and they are entitled to a minimum 98 days of maternity leave. However, the duration of the maternity leaves can be extended under certain circumstances. For example, female employees facing pregnancy complication, they are entitled to extend up to 15 to 30 days of maternity leave. Next, I'll pass it to Aisha. Thank you.
Okay, so next is the labor law is in Malaysia is regulated mainly by the Employment Act 1955. The law governs the term and condition of employment such as working hours, holiday and rest period, wage overtime, and other employment condition. The maximum weekly working hours have been reduced from 48 hours per week to 45 hours per week. Employees are also entitled to 30 minutes of rest after 5 consecutive hours of work. This is for Malaysia. For according to Chinese labor's contract law, employees should not work over 8 hours each day or 44 hours per week on average. After discussing with the trade union, the employer is permitted to prolong work hours, but they are limited to 1 hour of overtime per day. Okay, so next.
Okay, so for the conclusions, as we can see, the employment laws were created to provide guidelines and regulation for employers and employees and to offer protection and structure for both. So they are made up of laws spanning local, state and federal levels. And for two countries also, we can see that generally the employment laws in Malaysia and Hong Kong do not have a substantial discrepancy. Malaysian employment laws must be illustrated to be more well balanced in the eyes of the employees and require scrutiny when it comes to terminating an employee from the perspective of the employer. Nevertheless, employees in Malaysia are advised to be prudent in ensuring compliance with the EA 1955 and the recent amendment, while employers and workers must abide by the labor law of the People's Republic of China. So in China, there are legal framework that serve as an overview for employers, covering a range of subjects, including employment contract, working hours. So that's all from us. Thank you.
Thank you, sir.